The Ventura Superior Court Family Law Self-Help Center presents How to Complete Your Financial Disclosures. This video contains general legal information only and is not intended to constitute legal advice. Sharing information about your finances with your spouse is a requirement for getting a divorce or legal separation or annulment. This is called disclosure or financial disclosure. In this part of the divorce or legal separation or annulment, you will fill out forms to show what you own, what you owe, what you earn, and what you spend. You give these forms and copies of some financial documents to your spouse. You will use this information to divide your property and debts and make decisions about child and spousal support. Being upfront and truthful makes it easier to work out an agreement. If you hide information or if you are not truthful, you run the risk of losing property and being ordered to pay the other person's lawyer fees. Every party participating in the case, even if just entering a marital settlement agreement, must share their financial information with their spouse. The first time you give your spouse this information is known as making your preliminary disclosures. You must complete the preliminary disclosures by a deadline. If you are the petitioner, the deadline is 60 days after filing a petition. If you are the respondent, the deadline is 60 days after filing a response. You may need to share your financial information again later in the case. This is called the final declaration of disclosure. However, the parties can agree to waive the final disclosures if they're not necessary. If you exchange final declarations of disclosure, they are due 45 days before the date first assigned for trial. To prepare your disclosure forms, there's some general information and concepts that you need to become familiar with. Part of the disclosures involves identifying your property and debts. Property is anything you can buy or sell or has value. For example, a house, car, or furniture. It's also things like a bank account, pension, 401k, or stocks. You need to know when you married and when you separated to figure out what's separate and what's community. That is because anything acquired between those two dates is considered acquired during the marriage. The general rules for characterizing property and debts as community or separate are as follows. Community property is what you own or owe together during your marriage. It does not matter if a debt is only in the name of one spouse. If it was incurred during the marriage, it's community. Separate property is what you each own or owe individually from before you married or after you separated, and any gifts or inheritance. Property can be part community and part separate. For example, a 401k or retirement plan could be considered part community and part separate property. You will list all of the property and debts as either community, separate, or both. Typically, you keep your separate property and debts and split your community property and debts. These are general rules. There are several exceptions to these rules, and the division of property and debts can be complicated, especially if you have mixed assets or a lot of assets or debt. You may want to talk to a lawyer or the Family Law Self-Help Center to get information on how to characterize an asset or debt. Income can be from any source: wages, self-employment, commissions, royalties, dividends, rental income, etc. Expenses are your ongoing bills that you pay each month. For example, these can include monthly installment payments like car payments, credit cards, and loans. Since some expenses are not incurred each month, you will have to average them out to a monthly amount to complete the disclosure forms and estimate your average monthly expenses. For example, if you have homeowner's insurance that you pay $1,200 once a year, the monthly expense would be $100 per month. $1,200 divided by 12 months equals $100 per month. If you own a home and have a mortgage payment, you will need to know the amounts of your mortgage payment that are paid to principal, interest, property taxes, and insurance, even if you have an escrow account. You will need to attach copies of titles, deeds, and proof of ownership of the assets. You will also need to attach account statements of any financial accounts and debts. You will need proof of your gross income. Gross income is your income before any deductions for taxes, retirement, insurance, 401k, or anything else. If you get a regular paycheck from your employer, you will need 2 months of pay stubs and proof of any other income. If you are self-employed, you will need a profit and loss statement for the last 2 years or the Schedule C from your most recent federal tax return. If you have investment income, you will need a schedule showing your gross receipts less any cash expenses for each source of income. The forms you will need can be found in the form packets on the court's website. A direct link is included in the description of this video. There are several forms that are required to complete your financial disclosures. Online form preparation programs may be available to complete these forms. Please refer to the court's form packets for up-to-date information. If you complete the forms manually, they must be typed or handwritten neatly in blue or black ink. Here's some information to help you complete the forms. We will call the top section of each court form the heading. In the heading, you will write your name exactly as listed in the court case, your mailing address, and telephone number. Next, enter the court address of where the petitioner filed the case. This will be stated on the summons and petition. Write the name of the petitioner and respondent exactly as those names appear on the petition. Write the case number as it appears on the petition. A few important points regarding all the forms. Do not leave anything blank, even if there are no assets or debts. Either enter a number, 0, or write none. Do not write NA or not applicable. When disclosing your assets and debts, you will need to indicate if you claim it is separate property. If you claim it is part separate and part community, you will need to indicate that on the forms. Once the forms are completed and you have gathered all necessary attachments, you will make one complete copy of each form, including all attachments. Each copy needs to be stapled. You will keep the originals and serve a copy of each form on your spouse. Service can be done by yourself, either in person or by mail. Once you have mailed or personally delivered a copy to your spouse, you will complete the Declaration Regarding Service, FL 141. Once the FL 141 is completed, you will make one copy and file it with the Family Law Clerk's office. Please check the court's website for hours of operation and appointment information for the clerk's office. Thanks for watching. For more information, please contact the Family Law Self-Help Center. We are here to help every step of the way.